Are non-compete contracts enforceable?
Well, we are Florida lawyers, so our answer has to be an answer that is consistent with Florida law. We don't practice in other states, and so can't answer that question as it pertains to, for example, Georgia or South Carolina law. But non-competes in Florida are enforceable. We have a very specific Florida statute that provides parameters of under what circumstances a non-compete agreement, a confidentiality agreement, or a non-solicitation agreement are enforceable. Uh, in almost all cases that I'm aware of, the agreement has to be in writing, number one. Number two, it has to be signed by the person who is agreeing not to compete, not to solicit, not to divulge confidential information. And then it has to be reasonable, and it has to be protecting a legitimate business interest. Now, the questions of reasonableness have been the subject of hundreds and hundreds of cases here in the state of Florida that are reported in the appellate decision books. And typically, the law in this area requires an analysis of whether the restrictive covenants, as we call them, whether they're reasonable in time and geographic. And in that analysis, you have to look at what you were performing for your employer, what trade secrets, what information you had access to determine whether it's reasonable in time and reasonable in geographic. If you were the person responsible for the customers in a particular geographic area, for example, the Tri-County area of Dade, Broward, and Miami-Dade, Miami-Dade, Broward, and Palm Beach County, and you agreed not to compete or not to solicit in those counties post-termination, that would be reasonable because they're not asking you not to compete in the other 64 or 63 counties of the state of Florida. It's reasonable as to what you were doing for them and the areas they're trying to protect. Now, within the state of Florida, for certain types of employees or certain types of transactions, the parameters for how long is reasonable or unreasonable is set by statute. For example, with salespeople, any non-compete between 6 months and 2 years is reasonable. Now, I have plenty of clients who 1 year is reasonable and they don't need any more than that. So within those parameters, the issue is that sufficient to protect the legitimate business interests of your employer?